Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. We will start with the public reprimand of Judge Marty Levy-Cohen, case number 2024-0992. Judge Levy-Cohen, we're issuing this public reprimand because the Judicial Qualifications Commission found, and you agreed, that you committed misconduct and violated several judicial canons during your 2022 re-election campaign. You admitted to committing two distinct acts of misconduct. First, you disseminated unverified information that accused your campaign opponent of fraud. And second, to retaliate against a church where your opponent campaigned, you sent the church a letter with a false return address suggesting that the correspondence was from the Internal Revenue Service. As discipline, you agreed to the Commission's recommendation that you receive this public reprimand along with a 10-day suspension without pay. Judge, as you know, the canons require judges to uphold the integrity of the judiciary, including during campaigns for judicial office. There's also a canon that specifically prohibits judicial candidates from knowingly misrepresenting facts about themselves or an opponent. You've admitted that your actions violated these canons. Judge, I want to acknowledge that the Commission found that you have accepted responsibility and that you cooperated with the Commission in all respects. And those facts played into the mitigated discipline that the Commission recommended. But I also need to emphasize that misconduct like yours risks serious harm to the public's faith and confidence in our judiciary. To a great extent, public acceptance of our rulings and faith in the legitimacy of our legal system depends on trust in the personal integrity of judges. Any unethical behavior by a judge, including in a campaign setting, puts that trust at risk. Judge Levy-Cohen, please don't make mistakes like these again. Your reprimand is concluded and you may leave. Thank you. Counsel for our next case can come up. Okay, we'll now take up case number 2023-1576, Boyad versus Normandy Insurance Company.
Good morning, Your Honors. Good morning, Chief Justice. Thank you for your time today. May it please the court. My name is Mike Weiner here on behalf of the petitioner, Mr. Boyad. Seated with me at counsel table is Mr. Smith, his trial counsel. Your Honor, we are here asking you to answer the certified question of the First District Court of Appeal in the affirmative, that the sole act of a tortfeasor can satisfy the occupational causation element of the workers' compensation statute as long as there are work-related factors that cause or contribute to the injury. There are 5 principal reasons why we assert this is the correct and the only answer. Number one is the legislature has told us that, right? And I'll get into this in more detail, but the plain language of the statute clearly communicates a desire and intention that injuries caused, whether negligently or intentionally, by third-party agencies are compensable. Number two, because precedent matters. This court and the First District Court of Appeal have always recognized that a risk or hazards of employment test is the proper test for making an occupational causation determination. The first DCA abandoned that in favor of, well, some nebulous standard of Newtonian causation. Third, there are constitutional implications. If the certified question is answered in the negative, then there are serious concerns as to whether the workers' compensation system still remains a reasonable alternative to tort litigation for people injured in the fashion that Mr. Bouillard is injured. Number four,
that last one would seem to be more of a policy concern than a constitutional concern.
I don't think so, because when we talk about the constitutional concern, Justice Coriel, we're talking about the elimination of a right of redress that exists under the Constitution when the Declaration of Rights was instituted in 1968. Justice Kennedy, you wrote a very poignant dissenting opinion in the Westfall case, and you mentioned exactly that point, that when you have a right of redress that has been completely abolished, and we assert that what has been abolished here is the right of a person who is intentionally injured by a third party to seek redress through the workers' compensation system. So that does draw in constitutional implications.
Was that constitutional argument raised in the first DCA at all?
Well, we were the appellee before the first DCA, so we mentioned it, but we didn't really need to because we were the beneficiary. So we were just arguing at that point that there was competent substantial evidence that supported the judge's conclusions as to occupational causation.
But if it's not compensable, doesn't that open the door to a regular civil suit against the employer? And then
you actually got to point four before I did. Thank you, Justice Muniz. Yeah, so point four was that, and this is not just us sort of as lawyers, being Chicken Little and saying the sky is falling. This is the exact words of the First District Court of Appeal in Vigliotti, the words of the Third District Court of Appeal in Perez versus Public Supermarkets, and also the words of both dissenting opinions, the dissenting opinion in the motion for rehearing and the dissenting opinion in the case in chief by Judge Kelsey. And they all warned of the tort litigation crisis that flows from this decision of not compensability, because when the workers' compensation door closes, then of necessity, the tort door has to open, because you can't have somebody under our Constitution who's injured and has no rights to redress whatsoever, who has no access to courts. And so the question is a great one, because it compels your honors to answer the certified question in the affirmative, because otherwise, what do we wind up with? The whole raison d'etre of the workers' compensation system is to supplant or take the place of the unwieldy tort system that so employers don't have to defend these negligent suits, right? That's why Florida came up with this as part of the grand bargain in the 1930s to begin with. And we risk, by answering the certified question in the negative, disrupting the entirety of that grand bargain.
Do you accept the premise that if we kind of set aside the first district seemed like they kind of at the end of their opinion sort of went down sort of an unconventional path and raised these issues about whether third party torts, and especially intentional torts, whether they could ever be covered. But it seems like if this had just been analyzed under the more sort of traditional way of looking at these things, there would have been some sort of question about whether the employment subjected the employee to some kind of risk, which then kind of led to them sort of being harmed, and that's sort of the workplace causation connection. What sort of test should the court have for risk when it comes to things like this? I mean, do there have to be sort of distinctions among different kinds of jobs? Like if you have a job where you're sort of not really exposed to the public and your job is to kind of sit in your office and maybe you're a lawyer, you're a transactional lawyer or something, and the chances that you would ever be harmed by an assailant are very little, versus if you work in a convenience store or something, maybe they're higher. I mean, does the test have to sort of get granular like that, or could the test just be that being at a, in this day and age, unfortunately, you're exposed to, these assaults, and unless the employer can show that it was an external risk that you incorporated into the workplace, then it's kind of presumptively compensable the way Judge Thomas and her dissent talked about. I mean, what's the right way to think about that?
So I'm glad you asked. The legislature did not give any express text or clues within the text that would tell you that we treat different occupations differently in terms of how we assign what the risks are. So what we have is a body of case law that has existed since the inception of the workers' comp system that works exceptionally well. We just determine, were there occupational or hazards or work-related risks that help cause or contribute to the injury. We don't have to do a specific analysis of, well, police officers go to category A, convenience store clerks go to category B, desk workers go to category C. The legislature didn't tell us to do that, nor should we engage in that type of analysis. It is simply enough to show that you had work-related risks that caused or contributed to your injury to trigger or satisfy occupational causation. And risk has always, since the inception of the workers' compensation system, been how we establish occupational causation, right? Arising out of is nothing new. It has been ingrained in the statute since the statute's inception in 1937, when it was numbered Chapter 550-something. It was been part of the statute then, and since it's been 440.09, and it's been that since the 1940s.
So would you agree that it's not presumptive, in other words, though, that the claimant does bear the burden of establishing some sort of special hazard or risk associated with employment?
Only in certain circumstances, and I think the dissent from Judge Thomas explores that, and it talks about how the burden of proof is to shift in these matters, right? So for a claimant, it's enough for him to show that he was at work doing his job and exposed to some risk, and that satisfies the arising out of element. The burden of proof then goes to the employer carrier. If they're going to raise an affirmative defense that says, hey, it's something else that caused this, it wasn't your employment, they have the right to do that. But if they're going to raise that, they have to prove that. And that's one of the places where the First District Court of Appeal went remarkably wrong and off the charts by saddling the burden with the claimant.
On this
Yes,
burden
Justice.
of proof business, this is workers' compensation, and I agree with you about the trade-off that occurred in the 30s. We gave up on pretty much the tort system and developed this system. But if the claimant has the burden of having to prove that there's a hazard, specific hazard, think of all the hypotheticals out there. And I think Judge Kelsey brought up a few in her dissent. But would a teacher have to prove that teaching is a hazardous profession if there's a shooting in the school and she gets shot or he gets shot?
Yeah, I think.
How are you going to prove that it's no longer safe to work in a school? It's hazardous now.
Well, I think that sort of the occurrence of the accident or the assault speaks for itself, right? That tells you that what we're doing, and not to get too cliche about it, but common sense tells us that too. We know, and this goes to my fifth point that I didn't get a chance to mention yet, but we live in an unfortunate society today where violence is a real part of what workers encounter every day, right? We just had an example that happened a couple weeks ago, and it's an unfortunate part of the world that we live in. And so that violence is often directed toward workers, and we need to protect those workers. That's why the workers' compensation system exists.
Can we talk for a second about what competent substantial evidence you think there is to support the JCC's conclusion below about workplace causation? Say we agree with you that the analysis structurally is as you outline it. On what basis could the JCC conclude that in fact this was a workplace connected incident? There's this like ghost in the record about employees who were discharged right before, but that doesn't seem really to have any factual teeth in terms of connecting it to the assault. Instead, we have a very limited, it's the testimony, I guess, of two experts about, walking at night and the crime rate in the place. But if your theory is that this, like walking, like what you call the Newtonian thing, like the activity here was just walking from point A to point B, if you're criticizing that, then it seems to me that it's a very weird thing then to rely on that as the only workplace connection. Help me out and help me see what evidence supports the conclusion that this wasn't anything other than an assault.
Okay. I'm going to start by going back to what the case law talks about, the types of risks that exist, right? We have personal risks, employment risks, and neutral risks. This comes from the Hamlin case, from the Santizo-Perez case. It's well developed in the body of workers' compensation jurisprudence. What we know here is a matter of fact, that the judge concluded that there was no personal risk that led to the attack, right? He considered everything associated with Mr. Aponte as the shooter and ruled that out. Right. So what are we left with?
Which, by the way, I wonder which way that would have cut, because as I understand it, Mr. Aponte stayed at the hotel too.
He did, and that's an important point.
Yeah.
I
don't think we'd be here if it was actually Mr. Aponte, because he was a frequent hotel guest.
It was a risk that was brought into the hotel, right? Exactly. But so what are we left with? We're left with personal risks. We've eliminated personal risks. We're now left with occupational risks, and we're left with neutral risks. The case law teaches us that occupational risks are universally compensable. That's the law across the land, not just here in the state of Florida. Neutral risks are where, the sort of dispute can arise, right? But the judge of compensation claims identified A through G, I think it was, in his order, those occupational risk factors that caused or contributed. And they were all based on the evidence. They weren't just supposition. I get some things were maybe a little bit more of a logical leap of faith that he may have found in his order. But that doesn't mean that the other findings that he made about risks that were present and inherent in the workplace were not present. Those included the fact that he had fired previous employees, one of whom got fired for heroin. I don't think it takes faith to understand somebody like that is the kind of person who could possibly seek out retribution.
Okay, but that's a very thin read. Wouldn't it be better to argue that structurally the man's job involved letting people go sometimes, and that when that is part of your job responsibility, you can expect that there is a heightened risk of violence? Like, why aren't you making, well, now I've made the argument.
Well, I think that's part of what's in our briefs. And to add to that, there's also, angry customers. People get, given a bad deal by the rental car company, or some people, there's even reference in the record of what happened afterwards about, how they had to call the police because this lady didn't get her rental car, and, she was trying to rip the phone out of the rental car agent's hand. And so the judge identified all these things, including that, the shooting took place after midnight. Our mothers were all right. Nothing good happens after midnight, but that places you at a greater risk. The area where the shooter came from, right? The Mr. Bouillard had his back turned to this person, which made him more susceptible to a criminal attack. The location of the hotel, the fact that they had a high turnover rate, the fact that the security gates are left wide open to the public at all times.
So all those things were present here, but is the implication though that the court, within the constraints of the law, can't really that there have to be things like that just because Justice Coriell's question when he said, was this quote unquote just an assault? I think the implication is, unless you can point to things like that, if it's just, look, I was at work, I had to be there, it was part of my job required me to be moving around, and I was assaulted while I was working, and until the other side, shows that basically that was just like a personal feud or whatever, that where I just happened to be killed while I was at work, that that makes it compensable. I mean, does the law would that be a correct way to interpret the law, or do courts have to come up with these things? Because there's an element, it feels kind of contrived. It seems like what's really going on is just this sense that, until the legislature says otherwise and sort of has some specific way of handling these assaults, that, look, if you're on the job and you get assaulted, again, unless there can be proof that this was really just something that you yourself brought into the workplace, that, that you would, that it would be compensable, because, I mean, it just, so, this person who had the same job, like in a different part of town or whatever, it wouldn't be compensable for. It just doesn't seem like the workers' comp system and the whole idea of workplace causation necessarily requires courts to sort of like come up with these types of justifications for it.
I agree with you. I think it's enough to show some work-related risk. We shouldn't have to. The workers' compensation system, remember, at its foundation, and this is the words of this court going back years and years ago, was designed to be simple, efficient, cost-effective,
But
and
I think
even
what you're saying
legislatively.
is, like in response to Chief's question, though, there does have to be some showing of risk. In other words,
Some showing of risk. That's it.
Right,
And then
so
at that
it's-
point, if the carrier, I'm sorry, I didn't mean
Go
to
ahead.
interrupt. Yeah, at that point, if the carrier wants to assert that risk was personal and non-occupational, that's their burden.
right. So to your neutral, personal, inherent categories or occupational categories, the claimant does bear some burden to get it from the neutral category to the occupational category. Okay.
Yeah, and I think it's pretty well laid out by
And that-
Judge Thomas in her dissent. And this court has supported that as well in Zundel and the hacker cases about how the burdens of proof shift.
And to your point on legislative selection, the legislature does in workers' comp create presumptions for certain injuries, but there is not a presumption of work-relatedness for assaults, right?
No, there's not.
Okay.
No, but assaults are no different than any other category of injury. They are compensable. And if the legislature, I use the statement in one of our briefs that, they don't hide elephants in mouse holes. So if the legislature had intended that we don't want assaults to be compensable, they just would have said that. We don't have to go through this tortured reading of the statute to try to arrive at that conclusion like what the majority did at the first DCA. I think I might be into my rebuttal time, so I'll cede the rest of the time to my opponent. Thank you, Your Honors.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Bill Rogner, and I represent Normandy Insurance in this appeal. Stated briefly, Your Honors, in 1990, the legislature repealed the presumption that any injury that occurs at work is covered by the Act. That presumption was statutory, and it existed from 1935 through 1989. And in 1994, the legislature created for the very first time the arising out of definition, and we seek the application of its plain language. And according to this court, a statutory definition takes precedence over all and controls against all others, and the court may not engage in imaginative reconstruction of a statute to fashion a remedy.
Say we agree with you that the presumption was removed, okay? As just a first principles matter of logic, that doesn't mean there can never be recovery, it just means the presumption's gone, right?
Yes.
Okay, how do you deal with the fact that the legislature did not remove, remains in the statute, 440.39, which acknowledges that compensation for injuries when third parties are liable are obviously compensable or sort of by implication because that provision of the statute assumes that the EC is going to stand in the shoes of the victim and pursue the victim's remedies. So, I mean, it's clear that the legislature didn't close the door on will you concede that the legislature did not close the door on injuries when third parties are liable?
Absolutely, and that is why, Your Honor, I suggested to the court in my brief that you rephrase the question. I think the question is far too broad. This is what this case is about. It is about a premeditated, targeted, attempted murder of an individual. That's what this case is about. The judge, at page 26 of his order, found that it was a premeditated, targeted, attempted murder. They concede at page 56 of their brief that it was a premeditated, targeted, attempted murder. We have always agreed that that's what it was. Someone came to the premises of the employer with the intent to kill petitioner. That's this case, okay? And and they also concede that if it were personal, it would not be covered. And that's because we have a long-standing history of workplace assaults. When the spurned lover comes to the job site and kills her ex, that's not covered. Now, a workplace robbery, that's covered.
Unless, of course, the ex works at a jewelry store where
That's
he's
exactly
selling,
right.
getting jewelry for the new wife or whatever.
Exactly, Judge, because what we do when we look at these cases is
I guess that's my point, is that in this case, the victim is working after midnight at, a tricky part of town and, is often carrying cash, not necessarily carrying cash on this day, but we don't know whether the assailant knows whether or not he's carrying cash. Like, I think your statement of the bright line rule, while very attractive, is not really engaging with the facts of this case. And what I'd love to hear from you is an acknowledgement of what's conceded about the risks. I mean, the JCC found some real risk. What's the rule you want us to adopt? Not when it's just the spurned ex, here, I mean, that's not really the case. This is different. This is after midnight, all of this stuff. Can you help us work through this case?
Sure, absolutely. So we essentially have three possibilities here, as I see it. We have a work-related crime. He fired somebody, that somebody came back and killed him for revenge. We have a disgruntled rental car customer, unhappy with his rental car experience. He comes back and kills him, or shoots him. These are typical compensable work-related crimes. We can see that would be covered.
Like Stroher, where maybe we think he's got the money, like the Morrison cafeteria.
I agree, absolutely. The Strother case had circumstantial evidence establishing that it was work-related because they had proof that the perpetrators had cased the establishment before the assault. They had evidence that they were seeking the bank receipts that they thought she had.
I mean, the problem though is the work-relatedness. You're kind of begging the question. That's what's in dispute. We know that work-relatedness includes if you're, there's a cash register there and someone's trying to steal and they hit you in the face, before they do it. Obviously, the question here is, does sort of the condition, the environment, the exposure to the public when the assault occurs, does that make it work-related?
And I'll go back to the core of our case, Judge, which is the finding by the judge that this was a premeditated attack. This is not an opportunity crime. It's not.
Well, he said that it's weird. I mean, the findings were kind of vague on that in the sense that it said that it was targeted, but it wasn't, the JCC didn't really come to any conclusions about, I mean, I guess they ruled out the Aponte, but I mean, the whole thing, the findings are sort of a weird mix of sort of speculation about stuff, but then
I agree.
So that's kind of we've got the challenge of the first DCA sort of going off the rails. We have this weird set of findings here.
And Your Honor, the way I would respond, though, is that all right, workers' compensation is a creature of statute. We are supposed to be applying the statute. And you know what is not in Chapter 440 anywhere? Risk. The word cause or causation is everywhere throughout Chapter 440.
In your brief, I mean, you seem to accept sort of the risk paradigm. You talk about the inherent risk of being a police officer.
Inherent risk.
The inherent risk of being a teacher. Are you asking us to reinvent the wheel on
I am
that?
not.
Okay.
I am not. And in fact, Byrd versus Richardson is your case from 1989. And it talks about what risk are we talking about? And what you said in Byrd versus Richardson, which is a case I agree with wholeheartedly, a risk inherent in the occupation. A risk inherent in the occupation. So, for example, roofer falls off the roof. That's a risk inherent in the occupation. Police officer who is injured in the.
So if I'm a lawyer and something falls from the ceiling in my office and hits me in the head, is that a risk inherent in being a lawyer?
That's an occupational risk just
of anyone, right?
Of anyone in any occupation.
So if I have a job where I've got to be out and about and mixing with the public and taking cash from one part of the hotel to another at midnight and stuff, I mean, is that a risk inherent in my job that I may be the victim of violence?
Sure, it is. And the question is,
okay,
are you a victim?
So where does that leave? Where does that leave? It seems like where this leaves you in this case then is conceding that the claimant kind of met his burden and that you guys rebutted it by essentially proving, and I realize that the facts are strange.
Yes.
But it seems like your argument then would have to turn on sort of this targeted thing being sort of what shows that it's, because all those things could be true, that I have a risky job and I'm exposed and whatever. But if it turns out that it was my wife who came and shot me because she was mad at me, then all of that would become irrelevant, right?
I guess I would challenge the premise of your question. And the premise of your question is that we had the burden to prove anything at all. Now, between 1935 and 1989, if we don't know what happened, we lost, because the statute said, absent substantial evidence to the contrary, it is presumed that the injury is covered by the act. We no longer have that presumption. So who has the burden to prove work-relatedness? The statute says an injury arises from the employment if work performed is the major contributing cause of the injury. 44009, which is the coverage section, says the employer shall pay compensation or furnish benefits required by this chapter if the employee suffers an accidental compensable injury arising out of work performed.
So tell me why, okay, so keep in mind we're looking at this from a competent substantial evidence perspective. We're seeing, is there evidence that the JCC found that supports the determination? So we're not approving of all of the JCC's findings. I think it's fair to say he found a lot in the alternative. It could have been this, it could have been that, it could have been that. So looking at our perspective from competent substantial evidence and assuming that the claimant bears the burden of getting it from this neutral to risk inherent to the occupation or a hazard particular to the occupation, why is this not enough? So the JCC finds that the business is near the airport, it's open until midnight, the location has a high overnight guest turnover rate, it's located in a commercial area that's open to the public, it's next to a Hooters. They chose to separate the lobby from their office. He has to walk to the office with money. It's something that happens every day and at the same time of day. Well, maybe the correct term is night, and at the same time of night, at a relatively predictable time. Why isn't that looking alone, keeping away, like putting aside all of the who was it and who didn't, what was their motivation? Why isn't that alone enough to establish a hazard that was particular to this job?
I would have two responses. Number one, we have no evidence that any of those factors caused this injury.
So that goes to motivation, right?
Well, you don't have to prove motive, but in all the other cases that we're talking about where assaults are found compensable, we have circumstantial evidence tying the assault to the work. So in Strother, we have the testimony about.
Let me ask you about this. Didn't your own witness, your own expert witness, testify something to the effect that the shooting was a targeted attack on the victim, on the claimant, that was based on the use of inside information?
Yes.
Okay. So your own expert is saying that there's inside information that is coming from within the business. No, is that not right?
No, Your Honor, that's not right. That's what the judge found.
I thought you just agreed.
I misunderstood your question. I thought that's what the judge found. So that what the judge concluded. No.
I'm talking about what your expert testified to.
My expert testified there was no evidence that it was a inside job. My expert testified there was not one shred of evidence to suggest that it had anything to do with the employment. That was my expert. But think about this. This is really important in this case. Are we going to set a rule where you have to prove you work in a dangerous area to receive coverage? Because these kinds of considerations about, the census tract at his home was safer than the census tract at work, none of this is workable. And I submit it's non-statutory. The legislature created a causation test in 1994. Work must be the cause of the injury. Work performed must be the cause of the injury.
That doesn't get you very far, though, because I think the answer to what you're saying is, yeah, I think you're right. I do think some of these distinctions are kind of arbitrary. So why not say that if you have these jobs and you have to be there, that there's kind of this inherent risk? And if the carrier wants to show that it was a personal beef that caused you to get hurt, then fine. Then the person doesn't win. Just because you were at work, it keeps the distinction between the arising out of and the course and scope.
And my response to that would be because you are applying a presumption. You're applying a presumption that's causally related. And the presumption was removed by the legislature, and I say it was removed on purpose. Because in 1994, they had a special session of the legislature. They declared that there was a crisis in coverage. They said, what are we doing here? We are attempting to dramatically lower the cost of workers' compensation in the state of Florida. They restricted coverage. They added a variety of affirmative defenses. They criminalized fraud. They reduced indemnity, medical, and attorney's fees. They did so across the board.
I think the trouble with this argument for me is that if I summarize it correctly, you're saying that without the presumption, they lose.
Yes.
Okay. But the JCC disagreed with you.
Yes.
So, I mean, the question before us is a little different then. You're asking us to write on a blank slate, but fortunately or not, this is not a blank slate. You have proceedings below that are entitled to a certain degree of deference and some findings that absent the presumption, workplace causation was established, arising out of was a given. So help me understand how the rule you're advocating has anything to do with upsetting the finding of this JCC.
Okay, so the JCC found, based on zero evidence, none, that this was a disgruntled ex-employee, never identified. He then further found, with zero evidence, that this never identified disgruntled ex-employee obtained insider information from another never identified current employee, and then that the shooter made the strategic decision to choose location, lighting, landscaping to commit his crime. There's not one shred of evidence that is true. And if it were true, if there was evidence to support those findings, it's covered.
So far, you've been asking us then to reweigh the evidence. Is that what you're asking us to do?
My argument below, because I lost, or my client lost at the trial, my argument below was, argument number one, raised below, was there was zero competent, substantial evidence to support the factual conclusions that this was work-related. That was my number one argument.
Let's say we agreed with you on there wasn't competent, substantial evidence to establish that this was a disgruntled employee that got information for another disgruntled employee. And I think you got caught off when you were answering my question, but I was interested in your answer. Those kind of neutral facts that were found just on the kind of inherent danger of this location, the danger of being an employee that walked with money at a predictable time. You say that's not a cause. You say that can't be evidence that this caused the injury. Why is that?
Because it's simply a risk factor. I can be in an extremely high-risk area and nothing harmful happens to me. There's no evidence tying that risk to the injury itself. Because again, this is the premise of our entire case, was that this was a targeted attempted murder. Found by the judge, targeted attempted murder, conceded by the parties in their brief, targeted attempted murder. This is not a random crime.
And so you see a school shooting, a teacher in a school shooting situation as different because that is a foreseeable risk that would come to being a teacher.
Exactly. So that's,
I'm having a hard time
robbery.
Distinguishing that from a foreseeable risk, because we do think about workers' comp as replacing tort, and in tort, that's kind of the analysis, right? It's this foreseeable risk or special relationship or something like that would make an assault not compensable, but the employer would be liable under tort for something like that.
Right.
And so it's kind of, if you map that on to workers' comp, I'm failing to see the difference between. You have, like you typically would in a negligent security case, you have this crime grid, you have this increased crime in this specific area, it's inherent to this job. I feel like you're taking it a step further and saying that there also has to be evidence of the motivation of the shooter.
Well, first of all, things like foreseeability, things like that, those are tort concepts. We don't have that in workers' comp.
Right. It should be easier, presumably.
It is.
Okay.
Your injury is covered in workers' compensation if it's completely unforeseeable. If the injury has occupational causation, this injury relates to my occupation. If it had been shown through direct or circumstantial evidence that this shooting had anything at all to do with his occupation, it would have been covered. And the examples are taken from these other cases.
Well, let me ask you this. Now, if I'm a cracker salesman and I'm out doing my cracker salesman thing, going from little store to little store delivering crackers, and while I'm driving from one store to another, somebody runs to a red light and injures me. Am I covered?
100%.
Okay. Say I'm doing the same thing, going along the road, from store to store, I'm getting ready to deliver crackers, and I get hit by a bullet. Unknown reason. Just riding down the road. Bullet hits my car, hits me. Am I covered?
Your Honor, that would be considered a neutral risk, but
well, I'm just asking, because I'm trying to figure out how, based on the text of the statute or anything, we make a distinction between that negligent injury and what might be a negligent or Who knows how the bullet goes there? It could be somebody's partying in their backyard. It could be some domestic dispute. It could be an accident. Somebody discharged a weapon accidentally. We don't know. What we know is he got hit by the bullet while he's driving from cracker delivery to cracker delivery.
It could be a sniper who was aiming at you deliberately.
If he's a sniper aiming at you deliberately on purpose, that's not covered.
Okay, but who proves it? But anyway, go ahead and answer his question.
How do we know?
Okay, so the traditional way we look at that is we have risk theory, neutral. We have work-related risk covered, non-work-related risk not covered, neutral risk. That's a neutral risk. Think Mad Dog or being struck by lightning.
Why is it more neutral than the car crashing into him?
Well, the car crashing into him is compensable, and so would the stray bullet.
Okay, so you're saying both are compensable?
What I am saying...
You're saying the bullet is compensable as long as it's stray.
What I am saying is that in a targeted attempted murder where someone pre-plans to come to the job, they just come to the job to kill you, there must be proof of work-relatedness. And the way that we've looked at those cases before is they say, for example, Santizo Perez, the genesis of the dispute was the work. We identify... in that case, they identified the assailant, they identified the reason for the assault, and they determined that it was work-related.
I think I understand the distinction. So you're saying because the JCC found that this was a targeted attack,
that's the key.
That because it's targeted, there needed to be some evidence that the target was because of the work.
That's exactly right.
If there had been no finding that this was a targeted attack and that he was murdered by someone or shot by someone, then that other kind of hazard analysis might be more relevant, like the hazards inherent to the job, but because there was the target.
I agree with that, Judge, and that's why we have this whole body of case law where injuries, assaults, stabbings, and shootings are determined not to be compensable, or they're determined to be compensable based on the direct and circumstantial evidence that's offered. The problem in this case is, I say, that they had the burden of proof. They failed to meet the burden of proof. What I'm hearing is, well, wait, there's a presumption of some kind, and the burden shifted to me. What I'm saying is there used to be a presumption. That's why we have this whole body of case law from the 30s all the way through the 80s talking about the burden shifting because of the presumption.
Well, but hold on, because what were they supposed? So in this case, as Justice Sasso sort of went through the whole litany of things, they proved all these things about the sort of environmental risk, right? Did they then have to prove also that it was random?
Who has to prove it's random?
The claimant.
No, the claimant is the claimant wants to prove the opposite.
So the only reason why this whole issue of the targetedness is coming in is because of you, right? It's because you. That's sort of overcoming all of the whatever, let's put the presumption thing aside, because on the facts of this case, as Justice Coriel pointed out, the JCC wasn't relying on any sort of assumed risk. They went through all this stuff, and forget about the speculating about the disgruntled employee and everything. They did everything you're supposed to do, and then you came in and proved that it was targeted, right? Well, or the evidence showed it, but you didn't have an obligation to affirmatively prove that it was random, right?
No. Okay. The key to the case for us, Judge, the key to the case for us is the judge found someone came to the job site for a purpose. The purpose was to shoot petitioner. That's the key to the case. It's not a random crime. It's not a property crime. It's not a crime of opportunity. It's not
that rule. But that obviously proves too much, because if someone comes to the job site with the specialized purpose of robbing the victim, then you have the Morrison cafeteria case.
Right.
So targeting is like, I get it. I get that you're making this argument, as I said earlier, that the difference is between a stray bullet being part of the environmental risk and a targeted bullet being a different thing. The problem is it just doesn't hold up, because then it turns on the motive of the targeting. Because if it is a targeted bullet and you're hit by it while driving your cracker truck, but the purpose is to immobilize you so that I can steal all of your crackers, that's got to be compensable, doesn't it?
Right, but they have to present circumstantial evidence that some of that is true. So, Judge, I don't ask you questions, you ask me questions, but if this had been someone who he had a personal dispute with, totally unrelated to the employment. It had nothing to do with the job. He knows where he works. I'm going to go kill him today. And he came and killed him for something totally unrelated. That's not covered. It never has been.
And it would be the employer's burden to demonstrate that, right?
I don't know why it's our burden. Why is it our burden? There's no, right, Judge,
why isn't that like proving idiopathic? So the claimant has the burden of establishing that it's work-related. They do that through this risk hazard analysis that existed in Florida law. Once that is established, then the employer would have the burden of overcoming that through an affirmative defense like you would an idiopathic. It turns out it was not because of the hazard to employment. It turns out it was because of this personal dispute.
Right. Well, idiopathic means spontaneous or of unknown cause. This is not an idiopathic injury.
No, and I'm not saying it is idiopathic, but I'm saying why isn't it a similar function in terms of burden of proof?
Well, Your Honor, you asked earlier about presumptions. I think you asked Mr. Weiner about presumptions.
Yeah, and I don't think this would be a presumption. I think it would be because I think presuming any assault to be work-related would be problematic because of the legislature has chosen presumptions for certain injuries. This is not one of them. But if there is still this risk analysis that exists in Florida law, then we're not applying a presumption. The claimant has the burden to prove that it's not this completely neutral. There has to be some risk inherent to it. And so it would be a presumption. It would still be proving occupational causation in the way that it's always been done in Florida. And then there's this kind of like affirmative defense separate. So it wouldn't be a presumption.
But we say it as it's always been done in Florida. Always been done in Florida. So this statute that we're relying on, both statutes that we're relying on, were not in the law until 2004.
Right.
So,
and since 2004, that risk analysis, the Sedgwick case from 2019 from the first DCA, for example, that risk analysis for proving arising out of that something arose out of work has been consistent in Florida law.
Right, but assaults are special, and we have one case, Santizo Perez. Intentional assault.
Okay,
intentional
so this is sorry, Chief, and I'm going to go. Okay, this is where I wanted to get down because this is the rub. Do you see this as a CSE case, or do you see this as you disagree with the petitioner on what the test is to be applied in assault cases?
I think primarily it's a CSE case, and the reason I say that, Judge, is because we don't have a burden. They have a burden. They had to prove that work was the major contributing cause of the injury. And because the judge made that key finding that this was a targeted attack, someone pre-planned it and came there to kill him, they had the burden to show that the dispute, the genesis of the dispute related to the work. That's our case.
So what should we do with this certified question? Okay. You obviously are not a fan of it.
I am not. And Judge Muniz, I don't know why they did it. I suspect I know why they did it. It is a product of compromise and reflects a spirited disagreement amongst the judges on the First District. That's where I think this certified question came from. And as I said in my brief, I thought the certified question was far too broad because they talked about a third-party tortfeasor. A T-bone truck driver's covered. Nobody would ever assert that a T-bone truck driver's covered. This case came out in August of 2023.
Well, they did. I mean, in the court, it certainly suggested that they thought that was questionable.
I don't know that's well.
I think they did. I mean, you can read it that way, can't you?
I guess you could, Judge.
I think they would say driving is only the cause of my injury if it's I sprained my foot pushing down on the gas pedal.
I'm sorry.
I'm saying that they take such a sort of mechanical view of what work is.
I don't disagree. I have a problem with the certified question too, and that's why I asked you to rephrase it. I asked you to change it to include intentional tortfeasor. I wanted intentional tortfeasor in there. And then finally, at the end, absent proof that the assault related to the employment, because that's what this case is. It's a workplace assault case.
Why wouldn't we just answer their certified question? Because I think they seem to be struggling with this issue of can an assault ever be work related because of their theory. And so why would we not just answer that question? This is a CSE case at the end of the day, and leave the existing traditional test for assault alone.
I think you could absolutely do that because there is zero CSE to support the findings of the JCC. That's why I would agree with that.
Okay. Thank you very much.
Thank you.
Please the court.
He went over a little bit with our help, so if you need an extra minute or two.
There's a lot to unpack here. My colleague and my friend and I have much upon which we disagree, obviously. I'll start with, the whole, whether it's a targeted attack or whether it was a disgruntled former employee, those are alternative findings. They're really immaterial. You've heard repeatedly that there is an absence of any competent substantial evidence. I would submit to you that's not the case at all. Respondents don't like the evidence, but that doesn't mean there's an absence of it. And I would direct you to the judge's order in pages 37 through pages 43, where he identifies, I think, 7 or 8 different specific work-related risks that caused or contributed to the injury. Boom, there we have it. It's not a CSC
What's your response
case.
to the argument that because there was a finding that it was targeted, that takes it out of this risk and hazard to incident to the employment?
It's immaterial, quite frankly, Your Honor, I believe, because of the alternative findings. But even under the rubric of it's a targeted attack, the judge made alternative findings. It's targeted because of where he is in the zone of risks and environment, the zone of risk that exists in his work. The fundamental problem with the respondent's position is they seem to agree like, hey, if you could have solved the crime, you get the dime, right? That's the problem. We cannot turn injured workers into crime solvers as a predicate to compensability. The other problem with the respondent's argument is, well, if they would have succeeded in the crime, in other words, if somebody after they shot Bouillard would have taken all the cash out of the register or taken the keys for 5 or 6 rental cars and drove off with them, well, then you have work-relatedness. Now they're arguing that compensability should be tethered to the success of the crime. Those are irrational reasons that provides us with no stability in the law and no workable system, right? And so we'd respectfully submit you have to discard those arguments. You had asked a question earlier. I wanted to come back to it. We did, in fact, argue the constitutional question before the First District Court of Appeal, telling the first DCA that, yes, if you decide the case the way they decided it, there are constitutional implications. I just wanted to come back to that.
So on this, is the implication of your answer on the targeting question that if somehow, even if there's no question that the evidence shows that the motivation for the shooting was some sort of personal dispute that had nothing to do with work, that if sort of the work environment facilitates where and how the shooting occurs, that could actually be compensable?
This happens in some cases, right? We have, I think it's the Tampa seafood case, where they talk about that there was a private dispute, but the private dispute sort of was the genesis. The genesis of it was created in work. So there could be circumstances in which, some sort of the work creates an environment where disputes occur, and even though it may be a personal feud between 2 workers, it was the work environment that created the dispute. But when something's purely personal, it's not compensable. We agree. And had the carriers met their burden of proof after we initially established all of these work-related factors
so the claimant can't say, yes, it was personal, but the reason why this guy that didn't like me was actually able to shoot me when they did was because I was stuck at my job and I was more vulnerable, et cetera, et cetera. You're saying that type of argument would not be available? I
want to be sure I understand your question. Are we talking about 2 co-employees for the same employee?
No, I'm just talking, that's what I'm saying.
Okay.
Completely personal.
Yeah, so if it's merely fortuitous that the person is shot at work, then that's probably not going to be compensable, right? That's not what we have here, right? We have no evidence whatsoever of any personal risk or something that Mr. Bouillard imported into the workplace.
Well, except he's saying, and I think this is reasonable, I think, to infer that the fact that it was targeted like that, I mean, one reasonable inference could be that it really was a personal thing, that there was no attempted robbery, et cetera, et cetera. I mean, isn't that what they're saying? That's what they're saying. That could be an inference. That's an inference without any factual evidence to support it. So it's an inference stacked upon nothing. It's what I would call a big nothing burger. Okay, you can have 1 more minute. Okay. Well, Your Honor, I want to go back just really quick to the certified question. It is broad. It is intentionally broad. It's not just the question itself that's broad, but it's the words of the DCA talking about we have serious doubts given particularly the 1994 amendments as to whether an employee's injury caused solely by the act can be compensable. Please do not accept the invitation to make this a more narrow question. The question was purposefully phrased broad, both in the question itself and in the body of the
of the opinion. The stakes are high and the reach is broad. So in closing, Your Honor, we would ask that you please affirm the decision of the Judge of Compensation Claims, and in so doing, reverse the First District Court of Appeal, and also hold that the risk test is and remains the proper method by which an injured worker can establish occupational causation. And just one last point I want to make as I close with that is that the 1993 statute did not change anything regarding occupational causation. It's always been an element of proof. The only thing it changed is the quantum of proof, how much you have to prove. And major contributing cause doesn't exist in a vacuum. The case law from the First District Court of Appeal, there's probably about 9 or 10 cases we've cited in our briefs that talk about the fact that major contributing cause only applies where there are competing causes. In this case, there were no competing personal causes. The Judge of Compensation Claims ruled that out as a matter of fact.
Thank you. Okay, our next case is number 2024-0428, Stewart versus Perdomo Vindel. And I'm sorry if I mispronounced that name. Go ahead.
Good morning. May it please the court. Sandy Fox on behalf of Mr. Stewart. I'm joined by my associate, Sarah Ross. In this case, the trial judge denied the wife's request for prejudgment interest and equitable distribution, and the third district reversed. Under Florida Statute 61.075, marital assets include individual and jointly titled assets. In construing the statute, we look at the plain meaning of the statute, and the courts cannot add words to the statute, and that's what the third district did. Under 61.075 subsection 10b, it provides for post-judgment interest. The statute does not provide for prejudgment interest. The rationale that the third district used is that in following the fourth and second districts is that interest is okay to ensure equity, and we're compensating for loss and not to penalize. But that's not what's set forth in the statute. And what's set forth in the statute is the trial judge's ability to award an unequal distribution to accomplish equity. The legislature
Counsel, can I ask a question? So would you agree with the statement that a judge could look at a situation like you had in your case and find that one spouse had been deprived of an asset for some time that was marital, and calculate what the interest would have been, call it something different, and award it in equity?
So to answer your question, I believe the judge can look at the situation and say that a spouse has been deprived of the asset. But I don't believe that's the remedy. The remedy is an unequal distribution.
So they could calculate that unequal distribution using any formula that was equitable and within the court's discretion?
Correct, after consideration.
They just can't call it prejudgment interest?
Correct, after consideration of the factors for an unequal distribution with detailed findings, correct. So the legislature could have addressed prejudgment interest and equitable distribution, and they didn't. And we would ask that this court reverse the decision in Stewart for those reasons.
It seems that in light of Justice Groshand's question, this is a very technical holding you're asking us to reach. Essentially, you're asking us to say, if the same dollar amount is awarded by the court, it's just not called prejudgment interest, no problem. Is that your position?
My position is that in order to accomplish equity and justice, the trial judge can award an unequal distribution.
So let the word go forth, wink and a nod, that if you calculate it as prejudgment interest, but don't call it prejudgment interest, instead you call it an unequal distribution for equitable purposes, then the Florida Supreme Court says that's okay. But if you call it prejudgment interest, that's not permitted.
Correct, provided that you make the findings and it supports an unequal distribution under the statute, because the statute provides for an unequal distribution for equity. We start with the presumption that it's an equitable distribution, meaning equal, and the only remedy is the unequal distribution.
Well, wouldn't it be if you awarded prejudgment interest? It's not a right. I mean, it would have to be determined to be necessary, right? And the judge would have to make findings to award prejudgment interest just as they would with any other distribution, correct?
You would think so, but the statute doesn't provide for prejudgment interest. But if it was being done in the sense, for an unequal distribution, yes, the law requires that the trial judge make detailed findings of the factors.
So, my problem, I guess, with the argument that the law requires, these findings into unequal distribution is we're not looking at like whether there's holistic error with the order in this case. It's whether there's a statutory prohibition against awarding prejudgment interest. And so if we have this kind of affirmative permission to grant prejudgment interest in post-judgment context, why does that preclude as part of an equitable distribution when there's a bunch, you would agree, there's a bunch of catch-alls in these statutes, right? For any other reason, any other remedy, there's a lot of broad language that gives the trial court a lot of room to wiggle. And so why is there a prohibition? Just, I'm not talking about findings or what findings you need to make. The narrow issue of whether or not the trial court has the discretion to award prejudgment interest, what statutory language specifically do you think prohibits that?
Because there's nothing in the statute that permits it, and we look at the plain meaning of the statute. And when we look at the statute in a whole, it permits post-judgment interest. It does not permit prejudgment interest.
So what work do you think the catch-alls, any other remedy, for example, or any other factor that occurred in the relationship, or these big catch-alls that we see in the statute, what work do those do?
So, for instance, any other factors necessary to do equity and justice between the parties?
So that is not the remedy. That is the factor that the court has to consider in awarding an unequal distribution.
Could they consider that to award prejudgment interest?
If the statute permitted for prejudgment interest, but the statute does not say prejudgment interest. But the catch-all factor is the judge can make any finding to justify an award of an unequal distribution. But that is not the remedy. That factor is a factor. It's not the remedy.
Let me ask you about the timing of the valuation of the marital assets. Am I correct in understanding that that's discretionary? The judge can do that at the time of filing? It can determine the value of the assets at the time of filing, or the judge can determine the value at the time of the trial?
It's within the trial judge's discretion. So it's the date of filing, date of trial.
If that's true, I mean, this seems like that was going to have an impact on this very issue, right? I mean, like.
But in this case, it was valued at the time of the filing.
Right. In other words, it's one of the remedies that the trial judge can use, just like an unequal distribution valuation date.
But so if that's true, I'm just struggling. It just seems like you have just a highly formalistic argument that doesn't really fit in this equitable proceeding. Because you're saying there are these various routes that the judge can use to get to a particular result, but if the judge happens to say, well, you give interest, then that's not going to work. And I'm struggling with that. Now, I understand why you're making the argument, because I mean, that's to your client's benefit, but I'm struggling to see how that makes sense in the broader context of recognizing what the legislature has done here to empower the trial courts to deal with these issues on an equitable basis. I mean, this is an equitable sort of thing. I understand your statutory argument, but the fact that the legislature has dealt with that issue in the context where where that interest issue is particularly salient does not make me think. I'm just struggling to see why an implication arises that it requires this kind of formalistic approach that you're saying.
Because in a family law case, as you pointed out, trial judges have broad discretion with respect to the valuation date and also with respect to determining whether there's an unequal or an equal distribution. However, the judges are bound by what is in the statute, and the statute doesn't provide for prejudgment interest. And if a lawyer has an alternative approach, they need to ask for an unequal distribution. And that was not what was requested. What they requested was prejudgment interest. So yes, the equities may be able to be achieved a different way, but you can't add into the statute what the legislature did not put in.
Well, I guess though, but you're relying on sort of a negative implication principle that you're applying in a context where the statutory scheme doesn't necessarily support the inference that the failure to list prejudgment interest in connection with all this equitable stuff, that's sort of an intentional exclusion by the legislature. So is there, it seems like you wouldn't really, I don't think that the negative implication thing gets you as far as what you're saying. And I'm wondering, is there some sort of kind of broader background principle of law that says that sort of per se prejudgment interest is this kind of special animal that has to be expressly authorized by the legislature, just across law in general?
So not that I'm aware of. I think really what it boils down to is...
So if that's, so unless you're pointing to something like that, then it seems like what you have is an express authorization for post-judgment interest in the context of a statutory scheme that has all this kind of fuzzy catch-all equity, et cetera, and you're asking us to apply a negative implication in a context where the statutory scheme doesn't really lend itself to being viewed in this kind of comprehensive way that if, that only those things which are expressly authorized are permitted.
Well, the statute, the general case law regarding unequal distribution does not really touch on the issue of prejudgment interest. It's generally for dissipation, depletion, waste, within a close proximity to the irretrievable breakdown in the marriage. But that's not to say that there couldn't be a creative argument as to another basis as to why there should not be an unequal distribution instead of statutory interest. But again, the statute doesn't provide for statutory interest.
Can I ask you a question, just as a practitioner, related to the conflict case from the first? I'm not sure if I'm saying it right. Irusi. The first DCA said on this issue that the purpose of equitable distribution is to distribute marital assets equitably and does not deal in prior loss, entitlement, or unjust enrichment. And then they go on and say, because the marital assets are jointly owned and subject to distribution, neither party could suffer a deprivation of that property. Do you think that that is in line with it? Because, the statute talks about the factors one can think of as the contribution of each spouse to the acquisition, enhancement, or liabilities to the marital assets, the intentional dissipation, waste, depletion, destruction, other factors. Do you think that particular part of that opinion, not the result, I know you're arguing that the result was correct, but that particular language squares with how we understand equitable distribution?
Yes, of course, because you have to look at the statute as a whole. So it defines what is marital assets, either individual or jointly titled, and we start with the presumption of an equitable, meaning equal distribution, unless there's certain factors that are met to accomplish an unequal distribution.
So you think it's fair to say that this statute does not deal in loss, entitlement, or unjust enrichment?
Correct.
Okay.
Can I go back to your negative implication argument? The part where post-judgment interest is authorized, it specifically sub 10 says, it anticipates that there could be either a lump sum or installment payments. And in the event of installment payments, authorizes post-judgment interest. Why is that not a very specific grant to the court of authority to give interest when the court no longer has jurisdiction over the case? And if that's the case, why does that preclude the consideration of interest if the valuation is at the time of the petition?
So the rationale behind it is if you're awarding an equalization payment, it's going to be paid over time. So if one spouse doesn't have the lump sum, the person that doesn't have that money is getting interest. That's what the legislature put in for post-judgment interest. They did not put it in
this very specific context.
Correct.
Right?
They did not put it in for prejudgment interest.
So you think that the trial court is prohibited if the trial court, for whatever reason, has taken the date of valuation of the petition or an asset that's valued at $3 million, the one spouse has access to that during a 5-year separation and litigation. The other spouse has been living on whatever their salary is only. You think that the trial court is, and in the meantime, the stock market takes off. The trial court is prohibited from giving the spouse that was deprived of the money or the asset the time value of that money.
No, the trial judge is able to adjust the valuation date in order to achieve an equitable result.
What if the interest has been removed? What if the interest goes to a different account and has already been spent? It wouldn't matter the valuation date then, correct?
Well, then it becomes a dissipation issue or a depletion issue, and then the judge can award an unequal distribution. But for example, if you have a stock account that is at the date of filing has $3 million, and through passive market conditions, by the time of final hearing, it has $5 million, the judge is most likely to use the date of the final hearing, so both achieve the benefit. Thank you.
Thank you.
Morning. May it please the court. My name is Lisa Baird, and I represent the respondent, Michelle Perdomo-Vindel, in this matter. I would like to start off with Justice Grosshans, practitioner. Chapter 61 is all about doing equity between two parties. You know, we're not dealing with Exxon and Apple and all that. It's trying to allow both parties to move on in an equitable fashion. And what does equity mean? It certainly doesn't call for some inflexible rule of law, which would say you can award anything except for prejudgment interest. I believe counsel is focused on equal versus unequal and suggested in his brief, as a matter of fact, that we were calling for a third alternative, as it were, by adding prejudgment interest. When really, if you think about it, and I think, again, this goes to Justice Hands, Justice, is how do you get there? You know, subsection 1 of 61.075 gives a list of factors to be considered. They've stated in the legislative history that those were meant to serve as a guide.
Can I just ask, do you concede at this point that we, in fact, have jurisdiction in this case?
Do I concede that you do?
Yeah.
Yes? I'm sorry, is that a trick question?
No, it's not a trick question.
Yes, I believe you do have jurisdiction. What brings it here is the First District's opinion in Iarusi.
Yeah, but you know, there is this sort of weird language about how things may be different on remand. It was I thought a sort of an odd and not expressed in direct conflict. Tell me, I mean, you conceded. We'll press on, but.
Well, I conceded it maybe somewhat selfishly. I'd like to get rid of Iarusi. I think it's bad law. I mean, I'm protected in Miami because I argue our case. My colleagues in Broward are protected because of Catafumo. If you're in the first, lawyers are already arguing for an extension of it, that if it's not specifically mentioned in the statute, then you can't decide it. You can't consider it.
All right. So if we are here, I wonder, you know, the trouble with the argument about equity just sort of being this, I don't know, blanket that's thrown over the statute is that made in the way you've made it, it essentially reads the statute out of existence. If the bottom line is just do the equitable thing, court, then why have a statute at all? You know, the statute does go to the trouble of talking about the award of interest under certain circumstances and not in others. It seems to me like where the statute might leave us is where I was, you know, sort of discussing with your friend. The statute might leave us in a place where the right answer is no, you can't award the interest here, but you can make some other adjustment. Isn't that the right answer? I mean, because it seems to me like if we're actually giving the statute and its words their effect, we're going to track what it tells us to do with respect to awarding interest, but also to have larger equitable considerations in mind when squaring the circle between the parties. Is that not the right answer?
I think it is the right answer. I don't know why they're mutually exclusive. I mean,
well, no, but they are in the sense that, you know, if you just said, don't worry about where interest is awarded or not awarded by the statute, just read it with equity all the way through, that eliminates all, to my mind, of the chapter. There's the chapter could be real short.
I mean, I think I understand what you're saying, Justice Carrillo, because I thought of it the same way. Why allow for any factors and then say the catch-all, which is any other factor? But the legislative history, if you look at it, and it's about 300
well, this
plus
isn't
pages.
unique. I mean, the statutes do this all the time, where there'll be an enumeration of factors and then a catch-all. And this is a common problem in statutory interpretation. And there are rules about what we do in this circumstance. And one of them is, you know, at least not a very persuasive one, is, you know, read the enumeration of things to be a nullity because of the catch-all, which seems to me to be your position. And, you know, I think you'd be hard-pressed to say that we should give no effect to the enumeration. It seems to me that the effect we might give to the enumeration is what I outlined, which results in you know, perhaps a substantive win in terms of, you know, the outcome for your client, but perhaps if we're being careful, not a win about whether interest can be awarded in this circumstance. We would answer that in the negative. We would say no, but we would still say there are other equitable ways to fix this. Would you still count that as a win?
To be honest, I didn't really follow you on that. Maybe because what you first said.
If we said that interest could not be awarded here, right?
Right.
There are still some circumstances in which this is a win for you, because then we'd say, but equitably we can make the parties whole. Wouldn't that still be a win for you? Do you follow that?
Yeah.
Okay.
I mean, it still is a win. I think it's, you know, kind of what Justice Grosshens was talking about. They did it in Mississippi, and I thought it was kind of genius, where they said the husband's complaint in that case was essentially, well, they awarded prejudgment interest and it wasn't statutorily authorized. And the court said, no, they didn't do that. They found a way to get there by awarding the wife an amount equal to an amount that happened to be 8% interest, but it wasn't interest. So we kind of get there that way. The thing is, there's no prohibition on prejudgment interest.
What's your response to the argument that there is a prohibition structurally because the legislature has laid out kind of like the decision tree for what happens when you have a situation where a spouse is apprised of assets during the pendency of the litigation? You have the first DCA points out that you can get alimony for a specific period of time during your friend on the other side has pointed out that there's this intentional dissipation. If it's been moved to another asset, that asset can be divided. So the legislature has kind of filled in the gaps for this scenario, and prejudgment interest is not one of those options for the trial court.
I mean, those are other options, depending on the facts of the case. I mean, our case, it's kind of textbook for this scenario, asking for prejudgment interest. The husband held all the assets from January 3rd, 2018, until eventually my client was distributed in parts. How else do we fix that? There's no dissipation necessarily. Wouldn't it make sense to award a form of interest? I mean, to Mr. Fox's point, you talk about equitable or equal rather and unequal. How do we get there? And that's subsection 1 gives you suggested factors and then a catch-all part. So how we get there, how we get to unequal is perhaps under our circumstances, the interest. That's how we get there. Now, if there's $1 million to divide, they would each get $500. Now she gets $550 by a factor of interest. That's any other factors under here. Point is, it's not prohibited by statute.
Could you address, I think, something Justice Sasso brought up in the last, when the other attorney was speaking, that the award of post-judgment interest is a very specific thing addressing when essentially a case is completed, correct? It kind of follows the parties, but the case itself is done. That would be, in fairness, a fairly different situation than all the equitable factors leading up to that divorce or that distribution. What do you think that there is a distinction there?
I thought that's where you were going, and that's what I would say. There's a definite distinction because the initial factors under subsection 1 refer to how do we get to the equitable distribution, and then subsection 10b refers specifically once you've arrived at that equitable distribution, how do you divide it? And in my opinion, I was hoping there was actually something in the legislative history on this. There wasn't. But in my opinion, I can see a trial judge looking at our statute and saying, oh, okay, so it's considered fair. It's on the statute books. If I divide the assets, he keeps $500,000 and pays her, or vice versa, $500,000 over 5 years. That's fair because it's what the statute says. So I think they corrected that because it was already placed in the statute, and that would lead a trial court to believe that that's sufficient. I've done my duty, even though its logic is lacking there. Like it's not fair if I have to receive it over time. So
I don't know if this crowd would have cared that much about the legislative history, but it seems like really the post-judgment thing is kind of a distraction, and that if there's going to be a negative implication sort of drawn from this, it would really be more from sort of the comprehensiveness of what Justice Sasso was talking about than just the mention of the post-judgment interest in that sort of discrete context. And if the other part is so comprehensive that the failure to affirmatively mention prejudgment interest kind of implies that you can't do it, it seems like that's where it would sort of stand or fall.
Except it's not comprehensive.
Right. I think that supports you.
Yeah, and I understand what Justice Carril was suggesting. Like, why? I always thought that too. Why have anything at all then? But it's because trial courts do need a guide. I mean, you know, if you all served as trial judges, at some point they rotate you. And you may have 3 years, you know, in a position, so you need to get started. You need to hit the ground running, and the statute allows for that. It says think of this, 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 this. In 2018, that amendment occurred 30 years after the original iteration of the statute. The original iteration had in it, you may consider a payout over time, the installment payments. I can only imagine in 30 years how many judges said, well, that's fair. The second party gets paid out over time. It's fair because the statute says it. So we have to be careful of those inflexible rules of law. And the reason we're here, I got that too. I was really hoping that Judge Emis out of our court would have been specific and said, wow, we just totally disagree with the first. And he didn't do that. But y'all accepted jurisdiction, and I think it is important.
They said, to the extent that our remand for reconsideration is an implicit determination that the trial court has the authority to award prejudgment interest in the first instance, we know conflict with IRUC.
Well,
yeah,
I think it's because they didn't award it.
What was implicit express.
You know, it was a circuitous route to get there, but we're here. We're here now, and I think it bears repeating that prejudgment interest has been authorized by many states. I looked up everything in 50 states, and I found several examples since 1988 where this is what other courts are doing because it just makes sense. New York is most similar to ours, and they always say it's like an abuse of discretion in New York if you don't award prejudgment interest and the assets were valued as of date of filing.
Can I ask you this? I asked the opposing counsel the same. This IRUC statement that the purpose of equitable distribution is to distribute marital assets equitably, and it does not deal in loss, entitlement, or unjust enrichment. Do you think that that squares with the factors of equitable distribution in the statute?
I don't think it at all. I mean, I detailed that in my brief. I seized upon that. I think that's absolutely wrong. I think in every situation, when you read family law, it always comes down to, look at our case. He held on to all the assets. Would we be talking about this had he offered her $200,000 during the pendency of the litigation? I mean, it always deals in prior laws. I had one case in Broward where I hadn't even thought of it. The lady used $1 million inheritance during the marriage, though, and she had nothing to show for it. And the judge found at time of trial, yep, you use that. She doesn't have an inheritance now. Like, it's one of those factors. I'm dealing in prior loss, and I'm going to make it okay for her. And that's all we're asking this court to do, is eschew the inflexible rule of law that the Supreme Court has never been a fan of in terms of family law, and say you don't have to consider it, but you're open to it. It's out there. If you pick his side, then it's an inflexible rule of law. And if you go with us, it's like we live to fight another day. We may consider it in a particular case under a set of circumstances like we have here, or it may not be appropriate under another set of circumstances. Thank you.
Thank you.
Very briefly, the remedies to do equity are already in the statute. It's the date evaluation, which is within the trial judge's discretion, and also the court can also award an unequal distribution. As I also mentioned on page 9 of my initial brief, you can also get a partial interim equitable distribution. So those are the remedies in the statute. The statute does not provide for prejudgment interest, and we would ask that the decision of the 3rd District be reversed.
Thank you very much. We're adjourned for today.
All rise.